what she has asked for is a memo that seems to address the decision that Barr pounded his chest on probably most vocally, that Mueller, and perhaps it started as a whisper campaign, but eventually the story went like this. Mueller refused to make a determination on obstruction, so I have to. It seems that she's calling BS on that as well.
Yes, she is. And she's also calling BS on the fact that this memo was prepared in order to advise Bill Barr on his decision-making process. And what she says is the decision was made, whether it was made by Robert Mueller, who decided not to prosecute for whatever reason, or the decision was made by Bill Barr because of his own slant on things and his own efforts to spin it. And this memo, which we will see, which was ostensibly supposed to be legal advice, really was political and strategic advice that Judge Jackson says was designed essentially to do what Judge Walton said he did, which was to spin this in Trump's favor. And remember, as you pointed out at the top of the show, this really changed the whole messaging about the Mueller report. This was 3 full weeks, or maybe even a little bit more, before the redacted report came out. And it completely misconstrued what Mueller said. You played that clip, Nicolle, of him saying there was no collusion. As we've said, and I know Matt will speak to this as well, collusion is not a legal term. And Robert Mueller went to great pains to say that he did not look into collusion. But by the way, what we're also learning recently in the release of the sanctions on, or the issuance of the sanctions on Russia, is that there was collusion. Konstantin Kilimnik, who received internal polling data from the Trump campaign manager, Paul Manafort, gave it to the Russian intelligence, who then clearly could use that to help influence the election. So this was from start to finish Bill Barr's efforts to whitewash this investigation, and it continued in the Roger Stone case, in the Michael Flynn case. And we have yet another judge trying to call out a bad actor, a bad apple in an otherwise reputable organization, the DOJ, and noting, and all our viewers should understand, that this is exceedingly rare. No individual prosecutor, certainly no attorney general, gets called out for basically lying to a judge on 2 or 3 occasions.
I need you to say more because, as someone outside the system, it certainly seemed, maybe a little after the fact. I know these things take a long time to work their way through the system, but I'll find it, but I'll pull out the section. I mean, what she's saying is that basically this was a ruse. She writes this: both the authors and the recipient of the memorandum had a shared understanding concerning whether prosecuting the president was a matter to be considered at all. In other words, the review of the document reveals that the Attorney General was not then engaged in making a decision about whether the president should be charged with obstruction of justice. The fact that he would not be prosecuted was a given, as was the view from the Mueller team, we learned. I mean, talk about how egregious the conduct has to be, Dan Goldman, for a judge to accuse an ex-Attorney General basically of an elaborate cover-up.
Yeah, I mean, this is almost unheard of. You rarely get a judge opining on what an attorney general has represented or has said. Ordinarily, it's the line prosecutors and the line assistants who do it. I do think there's one area of the judge's opinion that's a little confusing, and it is the question that Mueller expressly said he was not going to make a prosecutorial decision. And at times it seems like she's saying that Mueller did make that decision. It doesn't matter in the end because she also found that this memo was essentially trying to paper over the rationale that Barr had already come to, and therefore it's not protected from FOIA. But this is really unfathomable conduct that you would have from an attorney general. And we may hear, Nicolle, a lot about, this is an Obama judge or this is, another Democratic-leaning judge. And that is the Trumpification of the judiciary, and we should not stand for that. Whoever appointed this judge is irrelevant. Chief Justice Roberts has pointed that out. These are judges in the federal judiciary who are calling out the attorney general himself. And that does not even count his own political meddling in the Michael Flynn case, in the Roger Stone case, in cases where he has no reason to be involved. So I think we will learn more and more. And I'd be curious what Matt says, because I think an inspector general investigation into Barr may be the appropriate means to look into this, only so that there's a public record of what occurred and that we can learn from it moving forward.
Matt, I spoke to a former senior Justice Department official this morning about just this and the reporting on it and what we know so far. And she had that same instinct that an inspector general's scope would be the best fact-finding mission. But I guess to the original point, who holds Bill Barr accountable?
Well, the American public has to ultimately. I think an inspector general investigation would be appropriate, not just looking into this incident, but looking into the entire politicization of DOJ under Barr's tenure. You know, looking at the entire waterfront, from the Flynn case to the Stone case to the politicization of, you know, even the antitrust division. You look at everything that he did. And I think ultimately, even apart from that, there has to be transparency in that the sitting Justice Department is going to have to make a decision to release some of these documents. Look, I think we will see this memo that is at issue in this case, but it's not at all certain. The Justice Department has until May 17th to appeal Judge Jackson's decision. They could try to do that. They may ultimately win. They may lose. None of us know. But I will say, you know, look, one of the things that happens when administrations change hands is, you know, the court cases don't just end automatically. You inherit the court cases that started under your predecessor. This happened to us in a number of cases in the Obama administration, and we had to make decisions about whether to continue to appeal Bush administration cases to try to keep information secret, or whether to just let the American public see it. And I will tell you, there are people inside the Justice Department, career lawyers and others, who will be arguing very strenuously that this decision needs to be appealed, that the Justice Department needs to protect its interests, it needs to protect the ability for lawyers to give confidential advice. And I just think that's flat out wrong. I know there were a number of, we had a lot of these close calls in the Obama administration, and I know we always had regrets about some of the things that we did. One of the things we never regretted was, you know, opening the door and letting the American people see the facts when there had been wrongdoing. And I think whatever happens with any kind of inspector general investigation, kind of from top to bottom, we need transparency to see all of the documents that, you know, the judge has called to be made public in this case, that Congress has asked for in other cases, and that continue to make their way through other pieces of litigation. This isn't the only place where, you know, litigants have asked for documents that the Trump administration, through the Justice Department, tried to withhold.
Hey, thanks for watching our YouTube channel. You should know that you can follow today's top stories and breaking news and catch up on your favorite MSNBC shows all in one place. Download the NBC News app today.